a competent registrar. We have a very supportive and guiding governing council. We have very well-defined rules thanks to the governing council members who helped us to put together a very transparent, well-defined rules. And we do have arbitrator panel, which is getting added with a lot of subject experts. And since it's by the chamber, our oldest chamber, we hope this could be a very value-added service as we go along. That is the objective behind it. And as far as the sessions are concerned, as you rightly pointed out, when we decided to have a full-fledged center, we started having these kind of introductory sessions. This is the 12th in the series. Every month, we have one subject under arbitration, starting from the emerging trends in institutional arbitration. If I remember right, that was our first talk, and we were getting very wide range of experts like you to talk on these subjects. And especially it's a learning for all of us, and as the chamber is moving towards a full-fledged center, it also helps us to learn the nitty-gritties, as Ms. Madhuri said. So this is a very big, I should say, a very lean background of the chamber, which I can share here. But I'm sure we will interact more as we go along and after this program also. And I would now request, maybe I'll just introduce you. I'll take the pleasure of introducing you to the audience, and then I will leave the screen to you. And Ms. Madhuri will again step in for moderation of the question answers and also concluding it at the end of the program.
Request for you to keep the introduction as brief as possible. Thank you.
Okay. How brief you want to be? 2 lines, 3 lines? I'll try to cut short. Okay. No, it's for the audience. Let them know at least a bit about you. So we have read you a full this one. So I have pleasure in presenting Mr. Shreyas Jayasimha to this audience. He read law at the National Law School of India University and was a Chevening Scholar at the University of Warwick. Incidentally, I worked with the British Deputy High Commission before joining here in the Trade Division. He brings with him 20 years of experience in litigation, domestic and international dispute resolution, and he had advised and represented clients across a variety of industrial sectors, including energy, aviation, space, nuclear power, infrastructure, oil and gas, and real estate. Really, that's a very, very big canvas, I should say, and should be of interest to the members of the chamber. He is a trained mediator and has been appointed as an arbitrator in India and internationally. He is a co-counsel for a state party in 2 significant investment treaty arbitrations, and that's why we would like him to talk on this subject today. He spearheads currently the Aarna, am I pronouncing it correct? Aarna Laws, Banking, Finance, and Insolvency Law Practices. He advises on an area of clients and including banks, financial institutions, NBFCs, and so on. And probably I should see he had been consulting on various issues, including recovery of assets wrongfully concealed abroad and round trip back to India, and also issues in relation to cross-border insolvency, which should be definitely of interest to the financial institutions and others. I would stop here since you requested me to make it brief. I would now leave the screen to you. Thank you so much for joining once again, and welcome all the participants. Kindly be on mute and keep posting your questions in the Q&A box. Thank you.
Namaskaram, and thank you, Ms. Saraswati, for the very generous invitation and introduction. May I take this opportunity to thank MCCI and MAMC and wish the latest avatar all the very best. Well begun is half done, and so it's a very promising future ahead, and especially with the past of 185 years, there's very few institutions, well, certainly in our country and maybe in many parts of the world, which can boast of such a continuous heritage. But that heritage, I myself come from a family with close to 100 years of practice of this profession and the law. And I understand that heritage brings with it responsibility. And so it's with that view that I'm speaking to you today to deal with what is considered a new topic, but frankly is not so. And it is at the same time incredibly important for both countries and investors to be aware of the broad contours of investor-state protection. Now, quite often, the first question that a lay audience asks is whether investment protection is the same as trade agreements between countries, or is it the same as double taxation avoidance agreements signed between countries? The answer to both of them is that it is a separate set of agreements. It is certainly not akin to the double taxation avoidance agreements. So that answer is a very clear no. It is not that. But there are aspects of trade agreements which may contain chapters pertaining to dispute resolution, which may fall under the broad umbrella of investor-state protections. There are some other types of contracts and agreements which might also provide protections to investors that are similar to those provided under investor-state protections. So that is trying to tell you what it is not. Let's try to approach it from saying, what is it? Let me go back to the end of the 1940s. The Second World War is just concluded. Many nation states are being born, including our own republic. And large capital, which is being invested in other states, typically followed a colonial path, that is from west to east or north to south, depending on which way you want to look at the map of the world. Now, when you talk about large capital, of course, is attracted to risk because it wants a return, but capital is very sensitive to risk. And when you're talking about investments that run into very large sums, several billions or trillions of dollars, very large periods of time, over 20, 30, 40 years, then the capital would be concerned with the type of environment that would exist in a host state. So we're now talking about capital going from one country, A, into country B, but the capital is not being provided by the country itself. It is by companies that are incorporated in country A that are choosing to make investments in country B. Investors in country A have the choice not only of B, but also C, D, E, and all the way up to Z. Now, therefore, while they are making their investments, they would be concerned to see what types of protections are accorded to foreign capital being invested into host states in these territories. Once again, before the notion of independence, you had assurances that would have been provided by either charters, by the various kingdoms that reigned in these states, assuring some sort of return to the private investor, or you might have had treaties of friendship and navigation. You will recall the days of gunboat diplomacy, most infamously practiced outside the harbors of Hong Kong, compelling a whole nation, that is China, which was resisting participating in the opium trade, to then succumb to being part of it. Now we have seen these examples over time, but in this new dawn that I had taken you to, which is the end of the Second World War, this was the birth of many new possibilities, the way of reimagining the world. One part of that process was, of course, the birth of the various Bretton Woods entities. Talking about here the World Bank, the IMF, and at that stage, there was also, of course, talk of a separate trade body and also a investment body, agency. Because of, again, resistance or lack of consensus, those decisions were deferred. Decades later, you have seen the ultimate birth of the WTO and a system of multilateral trade arrangements under that umbrella organization. In the context of investment, again, some countries chose to agree in the early 1960s on a convention called ICSID, which is looking at an international center for the settlement of investment disputes. So again, there is a cleaving away of trade issues from investment issues. Of course, they're related, but they're not the same. And you had some countries signing up to ICSID. There were many other countries that stayed away from ICSID, stayed away for various reasons, including perhaps a sense of waiting to see how this institution performs. Now, I have talked to you about the interests of capital and what it is sensitive to in terms of risk. And long-term risks would include political risk, risks that the industry itself has been able to provide some solutions to in the form of political risk insurance. But on the other side of the equation, the host state is seeking large investments into typically infrastructure projects, typically into, let's say, telecom, oil and gas, sectors where it might, some host states, at least in the 50s, 60s, and many decades thereafter, would have lacked either technical capability or the capacity to make such large investments. So the host state has a certain desire to attract the right type of capital. We're not here talking about hot flows of money coming into the stock market and leaving immediately. This is seeking to attract the more mature capital, capital that builds economies. And therefore, the host state is invested in ensuring that there are protections that are afforded to capital, that such that there is some assurance beyond domestic law. One might argue, why is this at all necessary? After all, countries have constitutions. Countries have parliaments, legislatures, and a whole body of domestic law. These may be sufficient for domestic investors, investors coming in from within that territory. But when you are talking about investments that happen across the border, there the practice has developed since the early 1950s. The first agreement was signed, or investment protection agreement was signed by our neighbor, that is Pakistan, with Germany in the early 1950s. And you will see that that happened soon after Pakistan got its first constitution. So why would a state, after having drafted and enacted a constitution for itself, then enter into a investment treaty, which frankly could be supra-constitutional, something that is above and beyond constitutional rights? Now, there again, it shows the extent to which that host state wanted to seem attractive to investments coming in from certain parts of the world. And therefore to say, look, don't go to countries X, Y, and Z, please come to country B. And these are the set of protections that we may be able to afford you. So there are strong policy considerations that on both the investor side as well as the state side in dealing with investment treaty agreements. Some of the, and you will hear me mention these words again a little later in the talk, but some of the types of protections would include fair and equitable treatment or full protection and security, national treatment, most favored nation, non-expropriation without adequate compensation. All of these are some examples of the types of protections that investors seek when it comes to negotiating investment treaty agreements. Of course, the period of time after 1950 has demonstrated that capital does not flow in one way alone. Look at the extent of investments by Indians overseas, Indian companies overseas, Asian companies in general, in several parts of the world, not just in Africa or in Southeast Asia or Eastern Europe, but even in the most developed economies, even in North America, in the United Kingdom, or wherever else across Western Europe. Therefore, although initially, perhaps out of a sense of politeness and respecting each state's sovereignty, the Germany-Pakistan treaty would have been referred to as a bilateral treaty. As I said, it might be a polite expression because at that time, there was no immediate likelihood of a Pakistani company investing in Germany. However, that sense of bilateralism, which perhaps existed only in name, has proven to come true in fact. And therefore, you have seen strong capital flows going the other way as well. And therefore, bodies such as this ought to be discussing a topic such as investment protection, not with a narrow jingoistic or hyper-nationalist view of protecting our great nation from some threatened extra protection by foreign investments, but rather to have a balanced view, to look at what does it really take to attract the right type of capital for development in our state, forget any other. And equally, what are the types of protections that Indian investors require from foreign states as they seek their journey internationally? And that would give guidance to our government in identifying what are the types of protections that Indian investors would be seeking while they are investing abroad. So therefore, this is not a treaty entered into between an individual company and a country. These are treaties entered into between two sovereigns. After all, it wouldn't be called a treaty if it is entered into by anyone else. The very fact that it's a treaty is between two sovereign nations. But one sovereign nation has typically in the past been representing the interests of investors. The other sovereign entity in the past has typically been representing the interests of the recipient of the investment, or the host state, as we will call it. But now, it's not just India, but several countries have a two-way approach to dealing with investment treaty policy, looking at both inbound investments and outbound investments. So with ISDS, you have seen a proliferation of treaties. It has become lawyers' paradise. And that is not a compliment to the area, to use that expression, because it has lacked a level of harmonization that perhaps the global community would have desired. But it is a fact of history that you have seen many individual countries entering into bilateral arrangements. So you have, for example, even India at its height had over 80 such treaties negotiated bilaterally. And incidentally, India's first treaty was in the early 1990s. We did not sign treaties in 1959, etc. Sri Lanka went ahead and they started signing up to treaties much earlier. But India, I suppose, being a very large domestic market, and of course we had other policies of creating a strong domestic manufacturing and consumption economy, and being somewhat resistant with a socialist bent of mind through the 70s to too much engagement with foreign capital. It was unsurprising, perhaps, that India's first treaty was in the 1990s. But it picked up very quickly in pace, and there were many such treaties that were signed up to. It is often said in a lighter vein that I'm not here talking about India, but some states signed up to treaties that they did not fully comprehend the consequences thereof. Because these treaties, as I said, might provide recourse to investors that lie beyond the laws of a country, that is, domestic laws. For example, you might have under a statute, let's say, an ability to approach a particular tribunal within a country for a dispute resolution. You might have, under the constitution of a country, the ability to approach a writ court, as you do in ours. But that's about it. And of course, you can go to the highest court of the land, which is in our case is our Supreme Court. But a domestic citizen or a investor in India can't go beyond. However, foreign investors have an additional recourse, that of arbitration against the Republic, against the state itself. Now, please remember what I had said earlier, which is that the treaty is between two countries. But the dispute is not between two countries. The treaty is between two countries. The dispute is between a company and a country. And therefore, typically, the investment treaty provides for two levels of dispute resolution. One is a level between companies and a country. Let's take an example where investor from country A invested in country B, but the entirety of their investment was expropriated. That is to say, it was nationalized overnight without compensation. So the investors would argue that there has been a taking of their property, investments, without any compensation. Therefore, they stand aggrieved. And they may have a concern that the courts of country B or the parliament of country B would not provide sufficient protection to their interests. So after all, the same domestic organs of state which have expropriated assets may not take too kindly for a request for compensation, either through a statutory mechanism or by recourse to courts within that territory. Which is why investors might seek additional supra-constitutional protections. Of course, this is to be used sparingly, and even most investors won't file investment treaty claims merely for every small inconvenience that they might face, every small road bump that they may face as they are conducting business. So with this background, I go back to explaining that while ICSID formed, the convention in ICSID gave one opportunity for countries to collaborate on a multilateral platform. Instead, you had many countries, including India, creating over 2,000 treaties across the world. Over 2,000 treaties being created bilaterally. And so there would be countries A and B having an agreement, Z and K having an agreement, L and Q having an agreement, and all of them intersay. So you had a web, and you continue to have a web of treaty protections that intersect across various parts of the world. So in this, you have as many of you would be aware of the careful thinking that goes into the questions of on where to locate an investment vehicle, what are the factors to keep in mind as you choose to locate an investment vehicle, in which country. Now, these various treaties afforded opportunities for investors to study the levels of protection being accorded to various territories, and then making their choices based on that study. Now, that has often been referred to as treaty shopping, that is, trying to choose one treaty over another. And of course, it is something that one will have to look at on a case-to-case basis. If there is an investment vehicle being created only for the purposes of seeking protection under a treaty, or if there is any other reason that went behind the thinking to locate an investment vehicle in a particular country. The consent to arbitration, that is to say, the dispute, you would have so far in your 11 lectures thus far been dealing with commercial arbitration, where the basis of the consent to arbitration is contained in a contract, and therefore such emphasis is placed on the arbitration agreement. In this case, under investment treaties, that consent to arbitration is contained in the treaty itself. It might be that the investor has, separate from the treaty, the individual company might have a series of contracts with the state entities that also provide for arbitration. But under the treaty for consent to arbitration, as you go to the, if it's an investment treaty claim under a treaty, you look to the treaty itself to see the consent that has been provided by the state. Now, quite often, there is an attempt to conflate the investment claims and contractual claims, and there's a large body of literature which I will not get into at this stage. But suffice it to state that the arbitration agreement, as it were, or the consent, is captured in the state itself, sorry, in the treaty itself. Now, there may be certain countries that provide for withholding of consent to certain types of arbitration. So there may be limitations that are placed in the treaty itself. For example, there's a treaty with, there's an example with New Zealand where it says that this consent shall not constitute by itself the consent of the contracting party. And therefore, something more is needed apart from the mere signature of a treaty. That again depends on how the treaty is negotiated and the specific wordings of the consent provisions. At this stage, I'm grateful for all the questions that have come in. Maybe I'll just respond to one of them before I continue, and I would request people to please continue to post them. There's one, for example, on national security, public policy are the only grounds to be concerned with the treaty that is signed. Are these not incorporated in the treaty itself? Now, again, I think the questioner has answered a large part of it in the question that he has posed. Now, what really matters is the content of the treaty. There is, this is an exercise of utmost responsibility by a nation state. These are not protections that are given, words that are said without consequence. And therefore it is, the treaty, of course, should be looked at very, very carefully. And if there are exceptions that countries want, it would, of course, be best practice to capture it as much as possible in the treaty itself. But of course, there may be extenuating situations. Let's take COVID situation that is not contained in your question per se. Right? The pandemic itself has led to some movements to say, let there be a moratorium on investor state claims, because this is a period of time which is abnormal in so many aspects of life. And that dynamic is playing out even in the relationships between investors and states, where there are situations where the state has had to step in, enforce lockdowns, for example, a simple act of protecting public health, which might prevent the normal functioning of an enterprise. And all of these sort of issues, which could not be thought of fully at the time of signing of a treaty. So yes, those may be issues that can be dealt with in specific claims before specific tribunals. But at a high level, it is often said that a treaty or even a contract is simply a disagreement reduced into writing. Just because there is a treaty or a contract doesn't mean that there is agreement. And this is especially so when it comes to treaties. And so quite often, a treaty is simply nothing more than a disagreement that has been reduced to writing. And therefore, some aspects of disagreement are best, again, captured to the extent possible. There are other tools that come out of this process, especially when it comes to interpretation. I'll just mention one of them right now. I have already told you that there are two levels within this sphere, either claims by companies against states or claims between states amongst each other. And those, the latter set, could pertain to interpretation issues. And one tool to deal with this thicket of interpretation is also for the states to issue a joint interpretative statement. Say, look, this is how we would like the treaty that we have negotiated to be interpreted. This is the meaning that we wish to ascribe as states, because after all, the treaty is authored by states, not by the investor company, and certainly not by one of the arbitrators. But many people who encounter investment treaty for the first time bristle with the idea that three arbitrators, typically not from the country, or at best one from the same country of the host state, have the power which is greater than somewhat their parliament, their highest court, and the extent of power that is then granted to this process. Again, there is no compulsion in signing treaties. Many countries have chosen to adopt a very different approach. Some countries have taken the view that we will leave it to economics and not to lawyers to determine where investments ought to go. Therefore, some of them have refrained from entering into investment treaties at all. Others have, as I said earlier, taken the route of multilateral investment treaties, and many have chosen to remain on the path of bilateral treaties. In either way, there are certain features of an investment treaty that are worth looking at, and that's what I will turn to now. First is, a treaty would seek to provide a taxonomy or a set of definitions that can provide consensus to concepts under the treaty. One of them would be to determine what is an investment. What is an investment under a particular treaty is also a matter of definition. Some BITs or bilateral investment treaties can be very, very broad and open-ended as to what their definitions of investment are. Others, investment treaties can be very carefully long clauses narrating specific types of investments. And other third types of treaties could be broad, but with certain exclusions built in to the broad definitions. But there are some common features, such as that the investments must be made in accordance with law, that the investment cannot be made ignoring the law that of the domestic state, let's say, or falling foul of it, and then yet uh, claiming protection. Again, these are matters which are fairly fact-heavy analysis in each case to determine whether particular type of investment meets the definition under the treaty under which a claim is made. Similarly, there are definitions of an investor who is a qualified investor to make claims under these treaties. There again, there would be some treaties which would perhaps recognize either natural persons or companies incorporated in their territories, others which explicitly exclude claims by persons who hold, let's say in the case of dual nationalities, nationalities of one of the territories itself. So, and then the test of uh, where the investor is based in the case of a corporate form is again a matter that will have to be looked at. The nationality of the legal entity would also be significant. The test to determine nationality of the investor is also a matter to be considered. There are other staying focused for a moment on the dispute resolution provisions. There are many other provisions of the treaty, but on the dispute resolution provisions, there may be some preconditions to the to arbitration. For example, there can be a notion of a cooling off period in which parties have chosen to keep claims in abeyance, to conduct negotiations, to try to resolve the differences. And there may be also other mechanisms available as to how arbitrators are to be appointed. It could be that it is one by each party, the two arbitrators appoint the third. It could be that if one party fails to make an appointment, some other designated individual or institution will make the appointment on behalf of a party. All of these provisions as to the preconditions to the selections of arbitrators are also matters to be looked at. You have the other protections that I mentioned to you briefly, which were many of you familiar with trade agreements will be familiar with the notion of national treatment. That is to say that the treatment of this foreign investor would not be worse off than the treatment being accorded to nationals of the same host state. That is, in summary, is what national treatment is. Other protections under the treaty could involve MFN, or most favored nation protections. And this is a little more hotly contested as to whether what is the extent of most favored nation protection. Is it going to pertain to specific parts of a treaty, or does it also pertain to the dispute resolution mechanism itself? And these are matters that individual cases go into. A word about the dynamic playing out. I see that one of the questioners is more concerned about this, and I'm grateful for these questions. But rather than responding individually, let me say I get the sense of the questions. Firstly, let me say that there is no stare decisis or a doctrine of precedent in investment treaty arbitration. That is to say, in the web of 2000 treaties that I had described, there may be several hundred arbitral tribunals that get formed. Each one might take one view or another, but it does not necessarily mean that the view is legally binding on another tribunal. Of course, being a body of law, decisions that are made public, not all these decisions are public, but if it is made public, surely one party will seek to assert that favorable ruling should be relied upon as a matter of guidance to the new interpretation that the tribunal is to come up with. But there is no mechanism such as the one that the question has asked, such as the advance rulings in the case of tax law. So there is, but there are countries which have created ombudsmen, which have created authorities to escalate any investor-related issue to one centralized authority. For example, South Korea has chosen that approach, and you have foreign investors who have a concern. Because look at the range of issues. Look at the range of issues that can be litigated under investment treaties. You've had the various, for example, the Japanese companies who were not very happy with some state actions. That is, of course, after all, India is a quasi-federation, and so many decisions are taken at different levels. So the alleged infraction of rights of a foreign investor might be a decision taken by a municipality, by a local body, by a state government, central government. And there are also more controversially claims under investment treaty which are triggered by decisions of courts. And so, for example, you have the Saipem versus Bangladesh case and others as well, where allegations have been made of court actions and inactions. And this no discussion on India and ISDS is complete without a quick reference to white industries. So amongst the many cases that India has seen now, the first that came all the way up to the award stage was white industries. There were other claims before white industries, such as GE, Bechtel, and others, but they did not proceed. And after all, that's the expectation in most investment treaty claims, that they don't proceed. When it is such a serious matter that in all probability, there will be efforts made by all parties to try to resolve the matter. But coming back to white industries, that was the case of an Australian investor that had contracted with Coal India, and they had a commercial contract that resulted in a dispute, that resulted in an arbitration, which resulted in an award in favor of the Australian company, which was also not very large. But that award was litigated in India for many years, such that the award remained on paper and did not convert into money into the investor's account. The sheer delay in the Indian courts of enforcing that award and of entertaining challenges to that commercial award resulted in the Australian company launching a claim against the country itself under an investment treaty. And it succeeded. But the way it succeeded was a matter which India and other countries took careful note of. The India-Australia treaty did not have a provision that existed in the India-Kuwait treaty. But the investor from Australia tried to use the MFN provision, that is the most favored nation provision, say that, look, if there is another foreign investor getting better treatment from India, even if it is under protection that is available in only the India-Kuwait treaty, but not in the Australia-India treaty, but because we have an MFN clause in the India-Australia treaty, that we should be reading in provisions of all treaties entered into by India with every country, and the best parts of that should be incorporated into this individual treaty. So obviously, that has generated a lot of debate. And since then, there have been a few other matters which I won't, in the interest of time, get into. But suffice it to say that in 2016, India chose to change its outlook towards this area of the law. And at that time, it chose to then notify a new model BIT. Okay, and that was a model which would be the template under which it would conduct its negotiations for other investment treaties going forward. It also chose to terminate many of its existing bilateral investment treaties, but many of these treaties have provisions to continue to stay in force as a sunset provision for many years after a state chooses to terminate the treaty. So therefore, even if the treaty was terminated, the protections afforded under the treaty would continue for a particular period of time. And that's the state that India chose to adopt. It has also successfully negotiated the model BIT based treaties with a few countries. And there's constant debate, and you've had many commissions, including the Justice Sri Krishna Commission, looking at what types of reforms that should be undertaken. But keeping aside the issue of India, as a whole, the environment around and the lack of certainty around investment treaty disputes and the range of differences and the extreme differences that have existed between one tribunal and another have now resulted in the United Nations itself recognizing that there's a major problem that needs to be addressed. So while in some countries, for example, or blocks of countries like the EU have been arguing for a multilateral investment court. So why have separate tribunals at all? Why not have an international court? And they have tried to argue that there should be a multilateral investment court. Others have resisted to say this is not a matter that an investment court can adequately handle. And therefore, there should be a continuance of separate investment treaty tribunals under individual treaties. This has resulted in a new working group called Working Group 3 in UNCITRAL, which is United Nations Center for Trade Law and Trade Reform. And they are currently debating reforms to investment treaties. Some of the topics, apart from the multilateral court topic, is of investment mediation. A mediation in the commercial context, and I'm sure you've dealt with this under contract, is a very powerful tool. But imagine how much more powerful it can be if it can solve and avoid, or at the very least, reduce the number of issues that are in dispute under an investment treaty claim. So there is a singular advantage to identifying investment mediation as a way to reduce the scope of the aggravation of disputes in the investment treaty space. So let me, as I come towards the end of this talk, leave you with the fact that there is a strong feeling across countries sufficient for the United Nations in one of its bodies to acknowledge that the investment treaty protection system requires reform. On that sentence, there seems to be some consensus. But then problems begin while you debate what is the reform that is required. How is it to be enacted? And this is where the UNCITRAL Working Group number 3 has come up with a lot of public consultations and position papers. They have also created an academic forum. And I have had the privilege of attending many of their deliberations, also as co-chair of the Law Asia UNCITRAL committee. And it's fascinating when we see events unfolding in different parts of the world where countries are not on speaking terms with each other. Our countries are at the brink of conflict. But on this stage, and it underscores that this is perhaps one of the most civilized ways of expressing differences, even if they're extreme differences. And so you have countries with almost opposing points of view, making rational interventions to each other at this forum, debating, trying to convince one another and those who might be otherwise engaging in the debate as to what type of protection should be there. So let me end by on a point of hope, and rather than focus on individual cases, and let us acknowledge that there will be instances. Which precise sector they will arise in, we do not know. It's like an infrastructure project. Even building of a bridge, building of a dam, you are assured that there will be some dispute, but that's not a deal breaker. It does not stop you from conducting the process of building. Similarly, when you're talking about nation building or building for future generations, be it from the perspective of an investor or from a host state, what we're doing here is building for future generations. And from that perspective, the focus must be on acknowledging points of difference and seeking to resolve them as best as they can through internationally accepted mechanisms, treaties, interpretative statements, investment mediation. If all that is still not forthcoming with resolution, then surely investment arbitration as well. So I want to say that this is an area which in-house counsel, advisors often don't look at unless they see it in the newspapers, and they often see it as somebody else's unfortunate problem. Instead, if we are able to see this as an opportunity for us all to contribute our ideas, and do not see it as much as a problem, but as an opportunity, and understand the real interests that are being debated, then I would encourage all listeners, including maybe the institution itself, to consider making a reasoned response to some of the debates that are going on in the UN, going on at UNCITRAL. Nobody is stopping the entrance of such views. So with that, I will end my talk and say, Ano Bhadra Yanto Vishwataha, there's always room for noble thoughts to enter any debate, and let us not exercise self-censorship in providing that. Namaste.
Thank you very much, Shreyas. That was really very enlightening for all of us. There have been some questions been coming up in the Q&A session. I'm not sure if you had the chance, but I can read it out to you.
Yeah, I saw them, and I have not taken on the references to individual cases.
Yes, yeah, I
for
understand.
reasons I've expressed earlier.
Yeah. Do you just want to throw light on this question on any specific reason why India has not signed the exit convention? And, is it better for India to actually sign the exit in the near future? I'm sure it depends on the WG3 outcome also is there, but we would just like to hear from you as well.
Yeah, I mean, I don't know ultimately if India will sign or not, but there have been many studies to highlight what are the hesitations that countries have had in signing up to exit. And some of those studies, and it's easily available online, So some of those studies have addressed the concern that some states might have, that the outcome of the treaties under ICSID disputes, the states might have thought that it would favor investors almost entirely. Many of these studies have shown that it is not so, that it is not that the investor always wins under ICSID claims. And so that is one of the major concerns that states have, is that whether there will be any chance of success at all. ICSID, of course, has its own share of problems in the sense that the challenges being made to arbitrators, any arbitrator being appointed in a tribunal, these are becoming de rigueur, becoming most common. In fact, ICSID itself has acknowledged this and has come up with a code of conduct for adjudicators on a joint project with UNCITRAL and ICSID earlier this year. And they have come up with a series of suggestions. But the scrutiny under which potential arbitrator candidates are put under is extreme. Look, for example, in a domestic context, when a person's name is suggested for judgeship, obviously lots of views are expressed. Now, similar is the case when a name is appointed as arbitrator. The distinction being that many times it is not a matter of public knowledge that there is a person being appointed. But under ICSID, there is, of course, a panel of arbitrators as well. And of course, countries can determine who they wish to contribute to that panel. So, these are some of the issues that ICSID is grappling with. There have also been some countries that have exited ICSID entirely in the past. And there have also been instances where countries that have quit ICSID have sought to seek re-entry. But I think, as Madhuri, you put it, the discussions at Working Group 3 have gone on for some time now, and many views are being ventilated. And I think that will give some strong steer to countries that will want to evaluate continuing in a bilateral investment treaty ecosystem or getting onto ICSID.
Okay, that throws some light on that. I'm not sure if you want to answer all these things, which is already there. So I think you have covered is what I would feel on that regarding the ISDS position and other things. I have one question that I would like to ask you.
Yes.
See, typically, we know that, as a foreign company investor who's coming into the country, I've seen the bilateral investment treaty, model bilateral investment treaty of ICSID, as well as India's model bilateral investment treaty as well. There's a clause which actually they have put in, which says that, you can you can complete your judicial processes and then subsequently need to go into your in an investment treaty. Now, why would that help? I mean, I'm assuming, as a layman who's actually looking at it, would look at it and say that yes, there is an investment treaty, arbitration treaty that is going to help me in a long run. But then if I have to, exhaust the judicial process that is available in the country and then go, that's going to take a long term to it. Any specific reason as to why they have got that kind of clause into the treaty itself?
Sure. Thank you, Madhuri. In fact, even without the clause existing in the treaty, the arguments are often made before tribunals that there is a duty to exhaust local remedies, that investors cannot be unmindful of remedies that they have domestically. For example, let's take a regulatory action of, let's say, building permissions, etc. Now, those inconveniences being faced might be easily addressed in a domestic forum.
Okay.
Now, to permit the investors to say that each and every obstacle that one might encounter in business in a country, and that to a foreign country, obviously there will be some challenges in any part, even in the best most stable economies, there will be challenges for sure. Now, every such challenge, if it should be permitted for the investor to escalate it to the level of an investment treaty dispute, is something that countries would want to ask investors to think twice about. And that's the thinking behind having the doctrine of exhaustion of local remedies. And there are, of course, other concepts I haven't gone into today, such as umbrella clauses or ways in which you can escalate claims under contract to treaty. But the links are such that, after all, the investor comes into a host state with some confidence in that host state's legal system as well. They're not just investing into the economy, they're also investing into the legal system. If there are such grave doubts, for example, some parts of the world where we now are not sure whether there's a government in power at all, and whether there is, who is in charge. Now, if in such a situation, an investor chooses to make an investment, now, should they claim to be surprised if something happens after that? Or if there are, as I said, think of it as a bilateral protection as well. So an Indian company, this may be easier to appreciate. If an Indian company is doing business in some part of the West, which is protected under an investment treaty, but if there is, let's say, a robust domestic dispute resolution mechanism within that territory, without pursuing those routes that are available to that to the Indian investor overseas, if the Indian investor chooses to file a investment treaty claim against that country, surely the Indian investor will hear an argument by that host state to say, please understand that we have a robust domestic dispute resolution mechanism. Please follow that and exhaust your local remedies. And in a way, it puts some healthy pressure on sovereigns to ensure that they do have a mechanism domestically to afford a fair adjudication of disputes.
You say that this should be a last resort for anybody who will actually, if there is a case of dispute. Just as a consequence, also, not a consequence, another question that has been lingering in my mind is, see, in your experience, typically, if the treaties, the investor wants some protection. For example, we've seen cases where, the countries have changed their laws or amended their laws retrospectively because of some dispute that has happened. But there is also, is there a case where the companies have arranged their affairs after the investment has happened to get some kind of a benefit from the government, or some kind of arrangement which they have made, which was not part of their investment? For example, a company is going to invest into a particular state, and then the state says you're going to generate so much of employment, you're going to generate so much of revenue, the GDP of the state is going to increase to a particular level. But then because of some taxation laws or some other reasons, they make some changes. Just, I wouldn't say it's a breach of the contract or a GO or a government that has been issued, but there's a deviation to that. Will the states also invoke these treaties to get some benefit? Yes, it can be done, is what I can understand. But in your experience, have you seen any of such kind of situations happened?
Yeah, so I had avoided the question in the chat box for precisely the reason that you have now asked me this question without mentioning the names of the case. Unfortunately, I'm not in a position to say much, Madhuri, on these cases. So all I can say is this: that treaty state practice. Sometimes we don't look at what other states do till the occasion arises. It's like not picking up a book famously for lawyers unless you get a brief that pays you to do it. Until then, you don't see it. So sometimes, there may be conduct that you think is very improper, but in one territory. Then when you look at it more closely, then you realize that it is far more prevalent. So this can happen, but I think the kernel of your question, away from the example that you gave, was that the states have to navigate the exercise of their sovereignty, recognizing that they have entered into several treaties. So that is surely what is going to be required. And I think this the very fact that we are even having this discussion, the very fact that there are increasing number of these discussions, I think there's, at the very first instance, there is such a huge information and knowledge gap between on what precisely does an investment treaty look like. And you say you looked at the model treaty. The model treaty is one, but there are many actual treaties that India has entered into, or other countries have entered into. As I said, it's a web of treaties, and and greater familiarity, greater debate is, I would say, the need of the hour. Without this information to then take strong positions triggered by the latest headline, one way or another, would cast more heat than light.
Thank you very much. Thank you. I don't see any more questions anywhere. If anybody has any questions, I'm not sure if there's a raise a hand option in this, but we can take one question or so. Madhu, do you see anything? Okay, I think we should not eat up your time anymore. So I would profoundly thank on my behalf and on behalf of the Madras Chamber also for immediately accepting to come here. And it was such a pleasure hearing you where you traced out the history right from the World War II till the current ongoing issues as far as and it is a very fantastic subject that that all of us can learn from time and again as we go by. And I would like to especially thank Anirudh at this juncture to have got you us in this forum to give us such an interesting presentation. And I thank all the participants for actually participating and posting these queries. And I would like to once again thank you for patiently answering all the questions, with all your difficulties that you have, that you're able, but still manage to give us the right answers, navigate through that. So thank you very much for this, and we hope to be in touch with you in our future programs as well. And then we hope we can trouble you for more of such sessions where we will go in depth on the technical issues, and we will be looking forward for your participation in not just as a speaker, also in the MAMC forum as well, so that it will be very, we will have such an expert panel for us as well. So thank you very much, Mr. Shreyas, and it was a wonderful session that we had. Thank you very much.
And you stay safe.
Thanks a lot, Mr. Shreyas. Brilliant session. Thanks, Madhuri, for moderating it so effectively.
My pleasure, madam. Thank you.
Thanks,
Thank you.
everyone. Stay safe. And enjoy your stay in Tamil Nadu, Mr. Shreyas.
Okay, madam. You're muted.
Thanks a lot. That's what I wanted to say.
Yeah. Okay. Have a nice evening. See you.
Very, very good. Yeah. See you. Bye. See you soon.
Bye. Bye.